Good morning, ladies and gentlemen, and good afternoon for those of you on Central European time. And I know we're expecting at least one delegate from Hong Kong, so good evening to you. Welcome to this Mercer Hole and Wilberforce Chambers webinar on cross-border insolvency, which has a focus on the consequences of the UK having left the European Union. My name is Chris Laughton. I'm a partner at Mercer Hole, where I lead the cross-border restructuring and insolvency practice. I'm a chartered accountant and an insolvency practitioner, and relevant to today's webinar, I'm a past president of Insol Europe. But for the next hour, my task is to chair this webinar, and I'm delighted to begin by introducing my distinguished guests from Wilberforce Chambers: Clare Stanley QC, Daniel Lewis, Rachael Earle, and Jamie Holmes. Now, I'll introduce them more personally as I invite them to speak, but first, some housekeeping. This webinar has been designed to address your questions, and some of you were kind enough to send your questions in advance, but I invite you all to ask questions now and throughout the webinar by using the Q&A function, which you should see if you hover your cursor near the bottom of your screen. So now, before turning to my learned friends, I want to briefly set the scene. How in 2021 in the UK do we deal with cross-border restructuring and insolvency? You'll all, I'm sure, remember the UK's Prime Minister David Cameron in 2016 calling a referendum where the electorate voted on balance to leave the EU. It wasn't what he wanted, so he resigned, and he was replaced by Theresa May. She wasn't able to agree a deal with the EU, and in late 2019, she was replaced by Boris Johnson. And he quickly signed a withdrawal agreement, which has got one tiny mention of insolvency, and Dan will come on to that. And then in the middle of the pandemic, when you might think he had more pressing concerns, he signed a trade agreement with the EU that doesn't mention insolvency at all. So it's a hard Brexit for insolvency. Dan's going to talk in a few minutes about the insolvency tools we've lost and about some we'll be making use of. But what I want to say is this: we have in the UK some of the most highly skilled, experienced and resourceful cross-border restructuring and insolvency professionals in the world. And I dare say we'll be hearing that the English legal system continues to be the best within which they can practice their art. Other jurisdictions may seek to compete with our schemes of arrangement, our restructuring plans, and even with London as a financial hub. But we will remain at the forefront of cross-border restructuring and insolvency. And one way we'll continue to excel will be by remembering the vital importance in cross-border insolvency practice of communication and cooperation. I say to all those IPs who think their way is best, only in your own jurisdiction. You'll do far better to have trusted professional friends who can tell you what will work best on their side of the border. So, with that introduction, I want to turn now to Rachael Earle, who is an insolvency and restructuring specialist, and her practice encompasses all areas of individual and corporate insolvency, and she has extensive experience of complex misfeasance claims. Rachael, what can you tell us about service of proceedings and extraterritorial reach in a post-Brexit world?
Thank you, Chris. Well, looking at service first, if we just remember the position pre-Brexit, so under the old CPR 6.33, a claimant didn't require permission to serve a defendant outside of the jurisdiction where the court's power to hear the case derived from the judgments regulation. But post-Brexit, and from the 31st of December 2020, we no longer have that regulation. So the judgments regulation and the service regulation have both been revoked, and our domestic legislation has been amended so that the Brussels and Lugano conventions no longer apply. So where does that leave us? Well, the first point is that CPR 6 has been substantially amended. the circumstances in which a claimant can serve without permission are now if the claimant is going to serve in Scotland and Northern Ireland, or where jurisdiction is conferred on the English court by the Hague Convention. So where there's an exclusive jurisdiction clause entered into on or after the 1st of October 2015. So it is just those three scenarios: serving in Scotland or Northern Ireland, or an exclusive jurisdiction clause to which the Hague Convention applies. One point to note is that the Civil Procedure Rule Committee, which sounds like a very fun committee to sit on, has in principle approved a further amendment to CPR 6.33, which would allow service out without permission where the claim falls within a choice of law agreement in favour of the English courts not covered by the Hague Convention. But that really is still those three exceptions going forward where you won't need permission: Scotland, Northern Ireland, or a jurisdiction clause. For everything else, you're going to need permission. And the usual rules apply there. So a claimant may serve out the jurisdiction with permission of the court if they can pass the three-stage test. So that's one, a good arguable case that the claim falls within one of the gateways under Practice Direction 6B. 2, there's a serious issue to be tried on the merits. And 3, that England is clearly the appropriate forum for the trial. So you may think that sounds like we're going to be making an awful lot of applications for service out, for permission to serve out. So will things get any easier? The answer to that is maybe. The UK has submitted a request to accede to the Lugano Convention, which would mean that permission wouldn't be required for service out on EU countries. So watch this space, but certainly for now, you will need permission to serve a defendant based in the EU where there isn't an exclusive jurisdiction clause. That's the key takeaway point on service post-Brexit. In terms of practical points, applications for permission to serve out are usually made without notice and determined on the papers. If you do get permission, the court will give directions about the time for the defendant to respond, the method of service, and it's also a good idea to ask for permission to serve other documents out of the jurisdiction, so that once you get round to witness statements, etc., there's permission for those to be served out of the jurisdiction as well. As to the method of service, service can be effected by any method permitted by a convention or treaty or pursuant to local law in the country that you're serving. So in terms of the points to remember, those amendments to Part 6 all apply to proceedings commenced after the 31st of December 2020. And the pre-Brexit rules will continue to apply to all proceedings commenced prior to that date. So a good idea to keep your old copy of the White Book and also buy a new copy of the White Book, irritatingly. Then moving on to the extraterritorial reach of the English courts post-Brexit. So that's, we're looking at after the introduction of the exit regulations and the retained insolvency regulation. And if we look at bankruptcy and liquidation first, the changes here aren't mind-blowing and they centre around a concept that's familiar to us, and that's COMI. So post-Brexit, the English court does have jurisdiction to open bankruptcy proceedings or wind up a company where the debtor, or the company as the case may be, has its COMI in England and Wales, or its COMI in an EU member state with an establishment in England and Wales. The interesting point in respect of liquidations is that these requirements now sit alongside the old common law principles, which do continue to apply, i.e. whether there's a sufficient connection to England and Wales, which Dan will cover in more detail. But the short point to note is that the post-Brexit legislation doesn't alter the English court's long-standing power to wind up companies incorporated abroad. And there's still a focus on COMI. When we look at CVAs and administration, things get more interesting. So post-Brexit, a company can enter into administration or enter into CVA in England if it's incorporated in England, Wales or Scotland. We might expect that. If it's incorporated in an EEA state, you might expect that. If wherever it's incorporated, it has its COMI in the UK or its COMI in an EU member state and an establishment in the UK. So far, so good. But the fourth option is that if the company is not incorporated in the E state, but has its COMI in a member state other than Denmark or in the UK. So that final one, that is a significant extension of the court's extraterritorial reach, because that allows a company incorporated outside the EEA, but with COMI in an EU member state, to go into admin or CVA in the UK. And then finally, just quickly touching on the sections of the Insolvency Act, which we've previously understood to have extraterritorial effect. So sections 213, fraudulent trading, 238 and 239, TUVs and preferences, and 423, transactions defrauding creditors, have all been held previously to have extraterritorial effect. And the key consideration in those cases, what the court's really honed in on, is the fact that the legislation uses the word any person. So to give an example, if a transaction falls foul of section 423, the court can require any person to repay a benefit received from the debtor. And that wording is said to confer on the court a power to make orders against persons, or in the appropriate case, property, outside of England and Wales, subject to the court being satisfied there's a close enough connection to England and Wales. But the odd one out, post-Brexit now, is section 236, because there's been conflicting authority about whether or not 236 has extraterritorial effect. And the latest judgment from the High Court in Re-Accurate in Liquidation 2020 decision said that it does not. It doesn't have extraterritorial effect. And that stems from section 2373, which I won't go into too much detail now, but it hinges on the wording of 2373 and the fact that the court may, if it thinks fit, order a person who, if within the jurisdiction of the court, would be liable to be summoned to appear before under 236. And that the focus of the courts there has been, well, if it can only be somebody who would be liable to be summoned appear before if they were in the jurisdiction, that must mean that if you're outside of the jurisdiction, there is no power to make an order against you under 236. And in order to get around that, in Re-Accurate, what the court said is that 236 can nevertheless have extraterritorial effect against persons resident in the EU via the recast Insolvency Regulation, because that can give international effect to otherwise purely domestic insolvency laws. The court held in that case that an application under 236 derives directly from an English liquidation, and it involves the exercise of a right under insolvency law. So the recast Insolvency Regulation steps in and gives 236 extraterritorial effect when it wouldn't otherwise have that under English law. So now we don't have the recast Insolvency Regulation anymore. Section 236 rather sticks out as an anomaly because it does use the words any person. But at the moment, it would appear that 213, 423, they do have extraterritorial effect, but bizarrely 236 is now on its own, and under English law doesn't have extraterritorial effect. So I think that's going to be an interesting point to see whether or not Re-Accurate is overturned by a higher court, and how they'll deal with that contradiction between the different sections of the Insolvency Act.
Well, Rachel, thank you. What I take from that is that service is a bit more of a problem than it used to be, but it might get better with the Lugano Convention. Jurisdiction, we've sort of extended it a bit with the new regime to be able to get one or two companies into administration, or CVA in particular, that we might not have been able to before. And we've also got a problem with 236, but let's see what the courts say when somebody takes the right case through to them at the right time.
Yeah.
Okay, well, recognition is really a pretty central thing as far as insolvency proceedings are concerned. And I'm now going to turn to Daniel Lewis to talk to us about the European Insolvency Regulation and our other principal cross-border insolvency tool, the Cross-Border Insolvency Regulations, or CBIR. Now, Daniel specialises in restructuring and insolvency matters, and his practice has particular emphasis on cases with an international element, particularly offshore asset recovery cases. So, Dan, tell us about the parts of the EU Insolvency Regulation that have been imported into English law. the retained EU regulation, as it's called, and how that works.
That's going to be a very short talk, Chris.
Yes, I know. But you can talk about other stuff too.
Thank you for the introduction, and thank you, Chris, for the rallying cry in your introductory words as well. It's very inspiring. What I'm going to try and do is I'm not going to go through all of the law pre the 1st of January and then compare it to the position that we're in now. I'm not going to do that except at quite a high level. I think we've got limited time, and I think that's probably of limited interest. We can all see what's gone, and as I say, spoiler alert, pretty much everything. What I was going to do is I was going to look at how the law might now develop, given where we are, and where those developments, what the sources of those developments might actually be. And it seems to me that from the commentary on this subject, and there has been an awful lot of commentary on this subject, one of the common themes out there is the uncertainty as to how cross-border cases between the UK and the EU will be dealt with in the future. But actually, it seems to me that the consequences are actually completely predictable, at least at a wider macro level. The situation is not unprecedented. On the contrary, we've got quite a lot of precedent for the situation we find ourselves in. I mean, we can look at it in two ways. Firstly, looked at from the point of view of inbound proceedings. That's simply a case of applying our law, and in particular the Cross-Border Insolvency Regulations. There's nothing surprising in them. They've been around for 15 years now. They haven't been used as much as they might have been used because of the recast insolvency regulations, but they're at least a known entity. In terms of outbound proceedings, looked at the other way, again, we know what tools we have, even if someone's come along and taken quite a lot of tools out of the toolbox. They're still the same tools that we had previously, and they're the same tools that we used in respect of many non-EU cases. For many years, in fact, for many centuries. So let's look at when the sun dawned on the 1st of January and where we were at that stage. As we know, we no longer have the recast Insolvency Regulation, and in its place we have the Insolvency Amendment EU Exit Regulations 2019. Now, we don't seem to have at the moment an abbreviated title for those regulations. People are using the retained insolvency regulation. Recent judgment referred to the adapted insolvency regulation. I think given how much is left, you might call it the reduced insolvency regulation. But at least it has, for those who find EU legislation quite wordy and long-winded, it has the virtue of brevity. Because really it only says one thing, and that's that how the courts have jurisdiction to open insolvency proceedings. Article 1 of the new regulation retains a test for jurisdiction to open insolvency proceedings based either on COMI or upon the debtor having an establishment in the United Kingdom, and that much is consistent with the recast regulation and very familiar. We know very well the concepts of main and secondary proceedings. But the exciting change, if it's an exciting change, is that the new regulation doesn't limit the jurisdictional gateways to those two bases, COMI and establishment, as once the recast regulation did. Instead, the grounds of COMI and establishment are, quote, in addition to any grounds for jurisdiction to open such proceedings which apply in the laws of any part of the United Kingdom. So what does that actually mean? Potentially, it means that the UK courts can open insolvency proceedings without the COMI being within the UK and without an establishment being within the UK, providing it's consistent with the common law. Now, it appears that the drafters of the insolvency rules don't necessarily agree with that conclusion, because if you look at the relevant rules, for example, Rule 1.7, and the forms that you're effectively required to complete, you're given the option of saying either that you have what are now called COMI proceedings, or you have establishment proceedings, or you have proceedings to which the adapted insolvency regulation does not apply. There isn't a tick box for other laws of the UK. But of itself doesn't seem to leave room, at least from a form filling in point of view, for the additional grounds contemplated under Article 1. But I think probably to let the forms decide that issue over the regulations is to let the tail wag the dog. What the words potentially mean is, firstly, that jurisdiction isn't decided in these cases anymore simply on a binary basis of either having COMI or establishment, but secondly, instead, on the common law test of sufficient connection. Now, as Rachel's already said, the UK courts have long had the power to wind up foreign companies, and that goes back all the way to the 18th century. And the common law test of sufficient jurisdiction is now very familiar. The English court can order the winding up in England of a company incorporated elsewhere, provided that there's a sufficient connection with England and a reasonable possibility of benefit to the petitioners. Now, that obviously is, from an EU point of view, completely heretical, because it goes against the whole purpose behind the recast insolvency regulations in terms of achieving a uniformity of approach and application, and in particular to prevent forum shopping, which is mentioned more than once in the recitals to the recast insolvency regulations as one of their aims. I have to ask myself, what's the point of maintaining the COMI and establishment tests for jurisdiction if you immediately go and water them down by including a sufficiency of connection test? In fact, why refer to COMI at all? COMI would be sufficient, would be a sufficient connection, as would an establishment. And I have my suspicions that COMI and establishment have been retained in the new regulations as a bit of a sop, to make it appear that the law that we're applying here is consistent still with the approach that was adopted under the recast insolvency regulations. Now, one of the areas, and I think Jamie may be talking about this a little bit later on, one of the areas where sufficiency of connection has come up again and again recently has been in the area of schemes and reconstructions under Part 26 and 26A. And although not strictly speaking insolvency proceedings, they are of a similar nature. And in those cases, the courts have been prepared to sanction schemes or reconstructions of EU incorporated companies where really the connection with this jurisdiction was pretty tenuous, either temporally or the grounds for jurisdiction being, for example, the amendment of a jurisdiction clause in finance agreements. Now, I think it's got to be open to doubt whether or not the EU is going to smile upon those cases in the future in the way they have in the past, because in the past there has been a jurisdictional basis in EU law for the recognition of those schemes or reconstructions. That seems to me to be an area open to serious doubt, particularly where in the EU they now have their own reconstruction regulation, and we're seeking to compete with jurisdictions which adopt a rather more restrictive view as to what their own courts can actually do in these cases. And if that's the case, why should they just open the doors and let us in? That all remains to be seen. I think one thing we can say is that if you apply that reasoning to insolvency proceedings more generally, I think the English court idea of good forum shopping is unlikely to be particularly attractive to our EU former partners. So the recast insolvency regulation has gone. What have we got in its place and what can fill the gaps? Well, the first question is, what about the common law? And I've already touched on that a little bit. As Lord Hoffman said in the Cambridge gas case, the common law on cross-border insolvency has been in a state of arrested development for quite a few years. And that's no doubt because of the recast insolvency regulation and the cross-border regulations and section 426 as well, which has meant that the common law hasn't really had to come in and plug the gaps that we can now see. So does that give room where we find ourselves now for the common law to fill those gaps? I think the answer is probably not. Rubin and Eurofinance, Lord Collins said that this was an area, the question of jurisdiction in insolvency proceedings, not apt to judge-made law, to legislation through judgments in the common law. And it was a question for Parliament, and it wasn't something that the courts could do on their own. And that makes sense, because in most of these cases, the way these things are supposed to work is with a degree of reciprocity. And obviously that's not something our judges can negotiate for us. And that conclusion in Rubin was obviously the same conclusion as was reached in Singularis and PwC, which also limited what the courts could potentially hope to achieve through judge-made law. The liquidators in that case had argued that where local legislation does not provide for relevant assistance to a Foreign Office holder, the legislation should be applied by analogy as if the foreign insolvency were a local insolvency. And that, Lord Sumption said, would have been profoundly unconstitutional. So if we're looking for common law to ride into the breach and fill the gaps, I think it's an unlikely candidate. Do the cross-border regulations provide a more likely candidate to ride into the breach? Well, inbound, certainly yes. They provide for a comprehensive range of powers in respect of foreign insolvencies and office holders in this jurisdiction, but outbound, their effect is more limited. They require enacting legislations in the individual states, so we know at the moment, I think we're limited to 4 jurisdictions where that legislation has been passed. So really, I mean, I don't want to sound like Donald Trump, but the CBIR actually gives people access to our markets without actually achieving any reciprocity at all. And that result isn't surprising, because if we expect some form of automatic recognition in these other jurisdictions, it's going to require some form of legislation in those other jurisdictions. And it so happens we know what that legislation would look like. It would look like the recast Insolvency Regulations, which we've just got rid of. So I think the prospects of there being some negotiated agreement in terms of jurisdiction and recognition at the moment seems pretty unlikely. So let's go and look at where we are after all of that. I think where you end up is obviously you end up looking at the individual laws in the individual states on a case-by-case basis. And rather helpfully, having created all of these problems for us, the government's produced a little pamphlet. And the little pamphlet, which is called the Cross-Border Insolvencies Recognition and Enforcement in EU member states from the 1st of January 2021, sets out how the government sees these things are going to work in the future. And I can just read briefly from the introduction. Under the heading, the international standard and best practice in this area, the introduction says, this process already applies to non-EU insolvency proceedings originating from countries across the world. It requires a court application and is subject to greater court scrutiny than the EU Insolvency Regulation, and represents a well-tested framework under which foreign insolvency office holders can seek assistance to deal with assets in the UK. The procedure that applies to UK insolvency proceedings seeking to deal with assets in the other EU jurisdictions is dependent on each country's own approach, and the assistance available varies quite widely. And then in a somewhat Panglossian way, the pamphlet goes on to list all of the different jurisdictions and optimistically suggests that in some there may be potential for automatic recognition. Well, those jurisdictions where there is potential for automatic recognition, Germany and Netherlands, I think, being examples of them, those procedures really are very much trimmed down and restricted compared to what we're used to. I think where we end up, as Chris has said earlier, is the need to cooperate much more in terms of practitioners in foreign jurisdictions. And if things are not going to be a bit bumpier and a bit less predictable going forwards, I think the only thing one can conclude from the government's pamphlet on cross-border insolvency now is that there is a great deal of opportunity for professionals both in this jurisdiction and others to earn fees. I'm not sure that was the original intention behind any of this, but that seems to be where we've ended up. Chris, rather a pessimistic ending there, I'm afraid, but no doubt you'll cheer us all up again.
Well, I'm going to cheer everybody up by reminding them of exactly what you did say, which is it's all about earning fees, which after all is why most of us are here in the first place. But with moving on from the frivolity, but keeping with a little bit of amusement, a question has come in that isn't so much as a question, it's just an observation on what you were talking about when you were saying it might be the residue of the insolvency regulation. Simeon Gilchrist of Edwin Co has suggested that it be called the ruins of the insolvency regulation.
Yeah.
Very poetic suggestion, Simeon.
There's something of that poem Ozymandias about that. I quite like that. Nothing beside remains. I think it's good.
There's another question that is more administrative that I just want to mention to all my guests, which is that someone was asking whether there will be slides, notes, transcript available for these so far excellent talks. If I get the positive indication from my guests, I hope I'm going to be able to say that yes, there will be some documentary follow-up that we will want to circulate. I have to look for nods because I'm not taking dictation. And there is a third question, and Dan, I don't know if you can see it if you've had a look at it in the Q&A, but I'll give you a moment to think about it because I'm just going to read it out. Section 5.1 of the withdrawal agreement disapplies the supremacy of EU law to all post-31 December 2020 legislation. But Section 5.3 of the withdrawal agreement is to the effect that Section 5.1 does not prevent the principle of the supremacy of EU law from applying to a modification made on or after 31st December, if the application of the principle is consistent with the intention of the modification. Could it be argued that the intention of the modification to para 111 of Schedule B1 was to preserve the jurisdictional grounds for opening proceedings under the insolvency regulations post-Brexit, not to extend the jurisdiction for EU domiciled entities where no such equivalent jurisdiction to open proceedings existed before Brexit for companies incorporated and domiciled outside the EEA? And could this mean that an administration cannot in fact be opened against an EU domiciled entity post-Brexit, save in circumstances where it could have been opened pre-Brexit, i.e. where there is no establishment in the UK?
Well, Chris, I think I'm going to have a moment to think on that.
Okay.
Come back to me at the end.
Okay, I will come back to you at the end. And in the meantime, I'm going to then move on. We've been talking a lot about European law and how we deal with it now. There is an old staple of the Insolvency Act, Section 426. And to talk about that, I want to introduce Clare Stanley QC, whose insolvency practice is closely linked to her broad commercial and trust practices. And she's experienced in high-value cross-border litigation, particularly involving offshore jurisdictions. Claire, tell us how Section 426 might help. And what about if I'm looking for help in another jurisdiction? Will I find similar provisions there?
Both of those are very good questions. I'm going to try and give you an answer. 426 deals in England, Wales, Northern Ireland, Scotland, and Guernsey, as I'll come on to explain, with incoming requests from foreign courts. Foreign courts in other parts of the UK and courts from relevant countries around the world. And for these purposes, a court of part of the UK is Guernsey. So Guernsey does have 426 and so is required to assist a request made by the English court, for example. Now, 426 is an additional way in which the English courts assist foreign office holders. So it's in addition to the CBIR, And I remember many years ago, shortly after the CBIR came to be introduced, I was acting for liquidators of an Isle of Man company, and we were going to, I was instructed by a very large American firm in London. We could just ask the Isle of Man court to make a letter of request. And my instructing solicitor looked at me with some disgust and said, "Claire, that's such a schoolboy error. We all know cross-border insolvency regulation applies now automatically." So we didn't need to go through that terribly elaborate process of applying to the Isle of Man court for a letter of request to come to the English court. We just had to make a very straightforward application under the CBIR, and it all worked out very well. Now, of course, as Dan points out, we are very generous to foreign office holders. They have access not just under the CBIR, but the courts of the place administering the insolvency can also make letters of request and ask under Section 426. Your question, Chris, about whether other jurisdictions have anything like 426, well, the answer is broadly no. Guernsey does, because it has 426 of the Insolvency Act 1986. But Ireland did have something like 426 in Section 250 of the Companies Act 1963, and was sort of like 426. It provided for automatic recognition, but that fell into disuse because of the Insolvency Regulation, which applies obviously in Ireland. And there is a successor to Section 250 in Section 1417 of the Irish Companies Act 2014, but it's not in force, and it requires a ministerial act before it comes into force. And one wonders to what extent the Irish will feel benevolent towards us and implement that section to assist English office holders. We'll have to wait and see. In the jurisdictions that I tend to work in, so the Caribbean, they tend not to have any a 426, but for example, Cayman has a statutory code for assisting office holders of companies wound up in the place of incorporation, and that's under the Companies Act 2020 revision, but it only applies to liquidations, so it doesn't extend to things like CVAs or administration. The Cayman courts do, however, apply quite generous common law rules about recognition and assistance. And I did a case in Cayman a few years ago called China Agritech, where there had been a winding up of a Cayman incorporated company in Hong Kong. So it had been wound up in Hong Kong as a foreign company. And it wanted to do, the liquidators wanted to do parallel schemes in Hong Kong and Cayman. But in order to do the Cayman aspect of it, they needed the Cayman court to recognize the Hong Kong liquidators and provide for statutory moratorium in Cayman. And Nick Siegel, who's a judge now in Cayman, was willing to allow my client liquidators to have recognition and to give them assistance in order to pursue capital reduction and parallel schemes. But he wasn't willing to go much further. So the common law as applied in Cayman, with that sort of limited exception, is very much limited to cases where the office holder has been appointed by the courts of the place of incorporation. And then you will find quite a lot of judicial assistance and that applies likewise in Hong Kong, Singapore, other parts of the Caribbean. So you'll find those courts being willing to assist in what ways they can. But the takeaway from this is that you will almost certainly need some court involvement. It's not going to be sort of turning up and saying, hey, I'm a liquidator appointed by the English court, please may I realise assets. It's not like that. You're going to have to assume that you need some court involvement from the place of where you're trying to get assistance. And so you'll need to take local legal advice, which is obviously not something that office holders necessarily want to hear. They're going to have to take legal advice in various different countries. So that's what I was going to say on 426.
Well, thank you very much, Claire. And certainly your takeaway there was very clear. It comes back to my point, I think, of communication and cooperation. We've got the hard yards here. We're going to have to go to other countries and find people to help us achieve what we want to do in outgoing cases. We've got one more subject area and one more speaker to introduce before we come back to answering questions. And please keep them coming using the Q&A function on your screens. My final guest, Jamie Holmes, has a busy commercial chancery practice focused around corporate and personal insolvency, trusts and probate, civil fraud and commercial work. He has significant experience of offshore work and cases that involve an international element. Jamie, what can you tell us about the enforcement of judgments overseas? What's changed for EU countries?
Well, thank you for that kind introduction, Chris. Just to pick up before I get to my subject, I saw there was a question asking if we're recording this session. I think one of our attendees is very diligently typing a transcript. In exchange for you possibly sharing that transcript, as none of us are writing one, I'll let you in on that we are recording the session, and we'll probably make it available in one form or another afterwards. So if you didn't mind completing the transcript, we'd be very grateful, and possibly even sharing it. But just to reassure you. But coming on to my subject, I'm going to be picking up on a number of motifs or more things more explicitly covered to a greater or lesser degree across what Rachel, Daniel and Claire have been saying. And I think my key takeaway is probably going to be the same as Claire's, that you're going to need some degree of a foreign lawyer assistance probably. I'm going to focus on enforcement in the sense of having insolvency proceedings recognised in another jurisdiction and enforcing through that against assets. But I'll also more briefly at the end pick up on enforcement of civil and commercial judgments of the kind that you would previously have enforced under the Brussels regulation or the Lugano Convention. So first, just starting with, as I said, I'm going to mainly focus on recognition and enforcement through insolvency proceedings. And again, I think, as I said, I'm going to be covering some of the things that people have covered already. I think on the position on inbound, if I can call it that, if you're assisting, if you've been asked, for example, to assist an IP appointed, say in France, who wants to try and realise some assets in England, and so you want to get those foreign insolvency proceedings recognised here. As Daniel's covered off, inbound, you've got the CBIR in place, and that's a relatively familiar process. You're going to need an application to court, and you may be able to obtain interim measures whilst you're getting that going. But if you manage to get that going under that regime, you're going to have a broad suite of powers, essentially all or a very large number of the powers under the 1986 Act to realise assets here. And outbound, as Dan was picking up on, it's a much more mixed picture. And I think, as I said, my main takeaway is that you are going to need some degree of foreign law advice. It may be a very light steer, it may be quite involved, and that you're going to have foreign lawyers acting for you in court proceedings. And I think the situation you'll be confronted with in each of the EU member states can be grouped into roughly 4 groups. And so imagine you're trying to realise assets in one of each of these jurisdictions, or you're looking at assets in all of them. The simplest, or at least the ones that's probably best to start with, are those that have themselves brought the CBIR into, or the intertrial law in one way or another into their own law, and that's Greece, Poland, Romania, and Slovenia. And the process is then essentially exactly the same as inbound, where you're trying to enforce or recognise foreign insolvency proceedings in England and then enforce here. So it's essentially the mirror image. But that's only, as I say, 4 countries. The second group is those that have relatively straightforward national laws, which may to a large degree mirror the wording of either the intertrial law or the European insolvency law. So you're going to have a large degree of automatic recognition and the ability to get at least some assets without a court application. I mean, in some ways, some of these regimes appear to be, and as I am I'm not a foreign qualified lawyer in any of these jurisdictions, but for what I've been able to work out about some of them, doing some research in this talk, some of them may actually be, in some small ways, more helpful than the position of the CBIR, but you're going to need local advice on that. The lion's share of countries the EU member states fall within the third group, which is where you're going to need some kind of application to court before you do anything. You can do anything of substance, and the point at which you need that court application is usually if you want to be able to get in or have administration of assets, which is probably the main reason why you're trying to get there in the first place. And then finally, there is a fourth group to bear in mind, which is there are some countries where it appears that there may be no ability to recognise English proceedings at all, and all you'll be able to do is open local proceedings afresh, which is particularly concerning. That appears to be the position, at least according to the government's guidance, in Hungary and in Denmark, but it may be that upon some foreign law advice that that's not quite right, and the position is slightly more nuanced than that. It might be helpful, I thought, rather than simply listing out a very long, large amount of information as to the nuances of each of these regimes, we were asked a really helpful question before the talk saying, could you compare 2 countries, say perhaps Cyprus and Spain? I'm going to, unfortunately, Cyprus is one of the countries it's been harder to get that much information about, so I might not use that particular comparison. I'm going to run through a few in a minute, but I thought it might be helpful to sort of pick out what it seems to me are some of the main considerations to bear in mind when approaching this. These will all be very familiar, but it's worth, I think, flagging, as you might take some of these for granted, given the situation we were used to previously, and that these now all are potentially up for grabs or risks that you need to bear in mind. So I think there are 6, and I'll run through them relatively quickly, but as I hope it will be relatively obvious what I mean. But the first is, what level of automatic recognition are you going to get? To what extent are you going to have to essentially re-establish everything you've already established in England, or is it going to be taken as read? Is your appointment going to be questioned and picked over? And what extent can you do things without a court application at all? The second point is, to what degree will there be a moratorium imposed and protecting you from cross claims by other creditors? If not, and to what extent is the debtor going to be prohibited from dealing with their assets in the jurisdiction before you've made an application to court? Thirdly, to what extent can you get assets? I think I've covered this already. In a number of jurisdictions, you're going to need to obtain executor. I'm not quite sure how you pronounce this. It may be pronounced differently in a number of the jurisdictions, but you're going to need that to get some kind of court order in place. And although some countries allow you to get in assets or deal with assets in the meantime, there are some varying caveats to this. So some countries you're able to get at the assets, but there's no moratorium. So is everybody else. Or you're able to get at the assets, but not assets in that jurisdiction, which I find utterly baffling. But that appears to potentially be the Dutch position. I think a fourth consideration is, whilst you're potentially making this kind of application to court, can I get an interim measure in place to protect the position if I'm concerned that there is a risk of dissipation in the short term? Fifthly, once I've done this, am I going to be able to operate under English law, or am I going to have to operate under local foreign law, in which case you might need really quite a lot of foreign assistance in working out whether you're really going to do this at all. or if you're going to have to instead try and bring another firm of IPs locally on board to deal with this. And I think finally, the sixth consideration, what costs protection, if any, will I have locally to recover from the debtor estate? So just to run through a few examples in case that makes them a bit more concrete or intelligible. If, for example, you've got some assets in Germany and the UK is COMI, you're going to have significant automatic recognition even to get at assets, as German national law largely follows the EU Insolvency Regulation, and you have an option to apply to court for formal recognition. If by contrast you're trying to get at some French assets, you've got a degree of automatic recognition, it would appear that you may be able to recover assets held in bank accounts, but no further than that, a distinction that doesn't seem immediately obvious to me. And there will be no moratorium in the meantime. So other creditors, and indeed the debtor themselves, will continue to deal with these assets. However, a French court, once you've made an application and had yourself recognised, will generally allow you, I understand, to operate under English law principles and use your English law powers, rather than making you have a sophisticated understanding of what the French position may be. And then to pick a slightly less helpful starting point, if you're trying to get some Italian assets, it would appear you're going to need a court application to be able to deal with assets at all. The Italian court might review everything about your appointment and apply a number of other tests. And it's only going to let you operate under Italian law. So bringing that all back together, as I said, there was a bit of a risk of getting lost in the wood for the trees, I think, here. Is the headline position is that there's a largely uniform procedure where you've got an inbound situation where you're trying to get a insolvency proceeding in one of the EU member states recognised here so that you can enforce against English assets. It's relatively familiar, you're going to need a court application. Outbound, where you're trying to get at assets in one of the member states, the key takeaway is the same as Claire's. You're probably going to need foreign lawyers. The devil is in the detail, and there is quite a lot of variety. Generally speaking, you're going to need a court application. It's not necessarily going to be problematic in perhaps even the majority of cases, but there's certainly more that you need to now consider. And at least in the short to medium term, it is probably going to add costs and at least some delay. Now, I said I briefly cover enforcement of civil and commercial judgments of the kind that used to be covered by Brussels and Lugano. This is itself a big topic, probably a bigger topic. So I will just do a whistle-stop tour. The short answer is, again, that it's a bit of a patchwork. There's quite a lot of overlap with what Rachel was covering in her talk, as essentially you're dealing with some of the same tools or same starting points. Brussels and Lugano still apply if you manage to issue and serve your proceedings before 11 o'clock on New Year's Eve, which might be relatively academic now as to service, but obviously you can still enforce all of those proceedings going forwards once they get to a judgment. So that might cover off some things for a while. And as Rachel said, England is applying to join Lugano. So it may be that actually plugs this hole almost completely if that happens. Parking both of those, going forwards, you've got essentially the same position inbound or outbound. And here, again, I'm going to whistle stop through them, but there are essentially 5 different positions, it seems to me. England has entered into a discrete arrangement with Norway, and only Norway, where we've agreed the Lugano Convention will continue between us, and that's in a 2020 statutory instrument. The second group is the old 1933 Act and a number of bilateral treaties with a number of important EU countries, such as France, Germany, Italy, and the Netherlands, and Austria and Belgium. Dicey's position is it assumes that position will simply revive now that Brussels and Lugano have fallen away. Query if your opponents will disagree with you, and you will have to have a seriously contested court hearing to work out if that's the case or not, which may well go on an appeal, as it's such a big point. Third, there are some sector-specific pieces of legislation you'd want to be aware of in merchant shipping, civil aviation. Fourth, there is the Hague Convention, as Rachel's already covered, where you've got an exclusive jurisdiction clause. And finally, you've got the common law if you're here, or whatever the local law position is in any of the member states. So here, the common law is relatively well known. You can pick up a copy of Dicey. It's a lot, as Dan was saying, there's a long, rich series of precedent here, and it's the position with countries all around the world that aren't in the EU. Unfortunately, with the other member states, it's again picking up on a familiar theme. It's going to vary country by country. You're probably going to need foreign law advice. And so with that sort of whistle-stop tour, I think I'll hand back to you Chris.
Thank you very much, Jamie. We are coming towards the end of this morning's webinar, but we do have a few questions that we need to answer. But if I could ask you to be brief in answering, and then we can try and cover several questions. What I would say to delegates who have asked questions, if you don't get an answer live in the next 4 minutes or so, we will answer the questions by email and follow up in that way after the webinar. But Jamie, could I ask you a question first? Is it helpful for restructuring plans to be considered to be insolvency proceedings? Now, here I'm referring to the Gate Group decision, which I think is regarded as somewhat controversial and in some aspects unhelpful. And I know that Barry Cahir of Beecham's in Ireland is keen to know what thoughts we have about whether that particular decision could be circumnavigated.
No, absolutely. It's a very interesting case for a number of reasons, the jurisdiction only being one of them, the other features of that particular scheme being very interesting too. I think the short answer is it could be a good example of hard cases make bad law, because if we get signed up to Lugano again, we've just managed to remove our new restructuring plan that we implemented in SIGA last year from the scope of Lugano. So we potentially created, the judge saw before them a situation where they very much wanted to be able to sanction, or at least allow them the scheme to go to convening meetings, and that was all that was decided at that stage. It was potentially shot us in the foot going forwards. And it will be interesting to see if even just in that case itself, how it holds up when it gets to the sanction hearing. I mean, clearly you're not alone, Barry. I mean, obviously K&L Gates interestingly wrote this letter to the court, which the judge wasn't hugely impressed about, and I've never really heard of happening before. But it was, fought a good fight. Didn't quite manage to persuade the judge, but perhaps some amicus curiae will show up at the sanction hearing.
Okay, thank you, Jamie. Dan, I put a question to you earlier that you needed a little time to consider, and I wonder if you've had sufficient time at least to give an indication of your thoughts.
Well, it does raise an interesting point actually, which is the extent to which when you read legislation now, insolvency legislation, you have to read everything with one eye to the Withdrawal Act, and I think that's probably quite a surprising place to end up. I mean, ordinarily, as a matter of statutory interpretation, you assume it means what it says. So my preliminary view would be it means what it says, paragraph 111. But we are going to be sending out some handouts or whatever after this. So if I find an answer that's contrary to that, if I can reserve my position and put it in the handout when it comes out.
I want to ask a final question, which is really a practical restructuring question, and it comes from one of my partners at Mercer Hole, Henry Page. Now, if a UK company might need to achieve a business and asset sale, should it seek to repatriate key assets to the UK so they can't be seized or attached in another jurisdiction? And if those overseas assets were the goodwill or the enterprise value of a trading operation that was part of the whole business to be sold, how might that value best be realised for the benefit of the UK company or its creditors? And this is from the perspective of insolvency practitioners who advise companies in restructuring as they're preparing to use an appropriate insolvency mechanism. That's when this sort of question arises. Dan, I can see you're itching to suggest a solution to Henry's problem.
I don't mind saying what I think, which is I think providing that any transfer of assets. I mean, I can't really say whether or not it's advisable commercially to do that, but what I can say is I think it's providing that any transfer of assets is not, you know, a disposition that could be challenged as an antecedent transaction. So that, for example, title to whatever it is that's being transferred changes, and you know, there's insufficient consideration payable. Unless that applies, and obviously if that did happen, then there'd be all kinds of remedies that the foreign insolvency office holder could look to use under the Cross-Border Insolvency Regulations without even starting secondary proceedings in the UK to set aside those transactions. But providing that's not the case, I don't see any problem with it.
I do see a potential problem with it, which is tax, because very often structuring and the location of assets has been arranged in order to mitigate the debtors and other people's tax affairs. And if you migrate assets back to the UK, you might, and I'm not a tax lawyer, but I would be very nervous about the consequences of that. And so the first thing I'd be doing is phoning up the tax partners and saying, leaving aside questions of insolvency, am I going to actually just increase the costs of this administration because HMRC are going to send me a massive bill?
Thank you, Claire. We have reached our allotted time, ladies and gentlemen, so I just want to sum up very finally by recollecting that the view we appear to have come to is that cross-border insolvency was never that straightforward. It's less straightforward now, but that's probably a good thing, because we'll be having to deal with more difficult things and spending more time on it. And we'll probably be involving people overseas doing the same. So, as I say, there are some questions that we haven't had time to answer. We will do that after the event. But we have had as many as 230 delegates with us this morning. Thank you all for attending. Thank you very much indeed to my guests, to Rachael Earle, to Daniel Lewis, to Jamie Holmes, and to Clare Stanley QC for your contributions this morning. Thank you everybody for attending, and it's goodbye.